Welcome to Antitrust Matters, a Constantine Cannon podcast where we have engaging and timely conversations about competition policy in the digital age. My name is Jeff Shinder, and I'll be your host. Antitrust has always mattered to consumers and businesses, but today it is also in the public discourse more than ever. From how we get our food on our plates, to how we travel, to the way we interact daily using digital apps and platforms, antitrust touches each and every one of us in ways we may not even realize. In Antitrust Matters, we bring you perspectives of experts and visionaries in the field who discuss where antitrust law has been, where it is going, and why it matters today more than ever before. In this episode, we continue our discussion where we left off last week. If you missed that episode, be sure to listen to it to get caught up.
Let me ask a question. This is directed at both of you. So we've talked about the Visa check case. We could do a whole podcast on the Visa check case and the Discover case. Those are really the two, as I see it, the two signature cases of the firm. Are there any other cases, less well known, that you believe embody what Jeff referred to earlier as the soul of the firm, the kind of case that's representative of, why you started this firm, Lloyd, and why you joined the firm, Steve, and opened the DC office? Is there anything else that comes to mind?
I have a couple, and it's in part the cases, but it's in part sort of the process. So I met Rupert Murdoch in 1992 for the first time. Personally. I was actually at a party at his home in Aspen, Colorado, and he knew something about who I was, and he said, "Oh, you're an antitrust lawyer." I said, "Yeah." He said, "I don't believe in that. I don't believe in the antitrust laws. I think they're bad for business." I said, "They're great for business, and the time will come when you will need the antitrust laws to protect your business." He said, "I doubt it." I said, I guarantee you that's the case." So that was in Aspen, Colorado in 1992. A few years later, his general counsel called me and said, "We need you and we need your law firm to represent us." And for around a decade, we were the principal antitrust counsel for News Corporation and all the Murdoch companies. And there were a couple of cases that came out of there, which were very important to us. So, for example, they had a business that was at the beginning of the internet. And at the time, the giant America Online, AOL, was doing something which would have killed their new business in Alexandria, Virginia. And we were hired to bring a plaintiff's antitrust case against AOL for News Corporation. And we litigated that in the Rocket Docket in the Eastern District of Virginia. We did a case where there were over 100 depositions done in only 9 months. And we took the case to trial only 9 months after filing this case against AOL. And the day that a jury would be impaneled, they threw in the towel and gave Murdoch and News Corp all the money that we had sought and all of the injunctive relief that we had sought. But we were, to some extent, we were talking about the importance of the antitrust laws and how, I think there was a traditional feeling that the antitrust laws were for the smaller companies trying to protect themselves against the bigger companies. But it was always our position that the antitrust laws were, the civil rights and civil liberties of the marketplace, and that everybody needed it. And all of the companies needed it all the time. So that was one case. A couple of years after that, for the same company, for News Corp, they were trying to buy DirecTV, and they had a deal to buy DirecTV from the companies that owned it at the time. And at the last minute, DirecTV, the owners of DirecTV had decided to sell DirecTV to the Dish Network to create what we said was a complete monopoly of the direct broadcast satellite business in the United States. And in some parts of the United States, that was the only cable-like service available to people in areas where there was no cable television. So the only place they could get a multi-channel, high-quality video in many rural areas and mountainous areas was through the DBS systems. And so we challenged that as a merger to monopoly. It took us around a year. We wound up doing advocacy at all sorts of levels in Congress, with the federal agencies. We visited 40 different states. And at the end of the day, there was almost a food fight among the federal and state antitrust agencies and communications agencies as to who would stop that merger. And then ultimately News Corp was able to buy DirecTV. So that was another case like that. I guess the third one that I'd mention was that, again, a very big company came to us, Johnson & Johnson, and they said, we have this situation with our competitor Amgen involving two pharmaceuticals that are used in conjunction with chemotherapy to boost the blood cells of chemotherapy patients, their red blood cells and their white blood cells. And they alleged that Amgen was doing something to force them out of the market and to monopolize the market. So this was Johnson & Johnson. And I was interested at the time. Why did Johnson & Johnson come to us? Why did they come to us? Because they were told by attorneys at Weil, Gotshal & Manges, a wonderful big law firm with a wonderful big antitrust department. They were told explicitly that the only people who sort of believe in this particular theory under the antitrust laws having to do with economic tying, and the only people who've done it and believe in it is this firm, is this little firm, Constantine Cannon. So J&J came to us, and we did that case against Amgen. At the end of a couple of years, they stopped the economic tying and paid our client $200 million in addition to stopping what they wanted to have stopped. So those are, I think, each and every one of those cases sort of is an expression of what the firm is all about, which is that the antitrust laws are there for everyone, and that sooner or later, as I said to Rupert Murdoch that day, sooner or later, your company, this market will need the protection and the force of the antitrust laws. And that's what the firm was started to do, and that's what we have done through the years, and that's what we continue to do.
Steve, why don't you have a crack at David's question?
Yeah, well,
that's a lot to talk.
I can think of a bunch, but not to take too much time. I'll say this. Over the years, and since I've been at the firm, and this is because of Lloyd's preeminence in payment systems, is we've had any number of merchants, restaurants, small store operators, et cetera, come to us because of the system of electronic payments and how there have been accusations about data breaches. And while everybody knows that data breaches really are the result of a crime that someone has committed against, say, a restaurant, there's a certain amount of responsibility there. But at the same time, the system as it's been developed over the years, driven by the major payment cards, has had this pernicious effect on smaller merchants in particular, and driving them towards writing big checks for, I think, on occasion, somewhat for questionable reasons. So for me, the most satisfying that we did happened to be a very, very small restaurant actually out in Utah that supposedly had a data breach. They were facing some fines and penalties of some consequence, truly material to their operations. They contacted us. Again, this is one small restaurant. This isn't a big restaurant chain. It's a small restaurant, for help. And the bank that was involved in this, which is a very, very large national bank, kept pounding away saying that this restaurant owed a lot of money. Didn't think they did, but they did. They kept doing that. And they actually took the step to go into state court in Utah with a debt collection law firm to get the money that they said this restaurant owed. We got involved in that. And instead of paying, we actually filed about a 50-page counterclaim against this large bank, pointing out all of the issues, errors, deficiencies, et cetera, in that. And I am happy to say that by the time the dust cleared, which was about 3 years later, this restaurant had been vindicated in absolutely everything it did. And I cannot go into the details of the settlement that occurred, except to say that our client was very happy about it. But that has happened. It does, and it continues to happen all over the country, all over the world, where there was just imbalance in the payments world. We probably enough said about that, but that was just the be able to take on that little small restaurant as against these very large entities and come out on top was terrific. And Jeff, the other thing I would say that I was not really even involved in, that you were involved in, was the Native American tribes in Florida, where you took on and others took on their cause and were successful. And I remember at the time not being involved in it, knowing just enough to know that, I am really proud that this law firm did that. So I don't know if you want to mention one thing about it, but I'm just telling you that always has stuck in my mind as a fine example of what the firm is capable of and the causes that they are happy to support.
I'll comment on that, that was a First Amendment case. It involved the Immokalee workers. And I guess I'm very proud of that case, too. I didn't lawyer that case. Others of our partners lawyered that case. But I had the pleasure of teaching that case when I taught a First Amendment course to undergraduates in the state university system and at Williams College. So I'm very proud of that case. I would like to mention one other area that we've been very active in, which is telecommunications. So as I said before, part of the genesis of the firm was this one client coming to me when I was at McDermott and asking whether we could represent them. And I said I could not in my then current firm. And that led to the founding of what is now Constantine Cannon. We were representing a company that was challenging what was then a monopoly in New York City by Time Warner Cable. And at the time, the only way you could get, multi-channel video in New York City was from Time Warner Cable. And this was a company that was challenging it. It was called Liberty Cable. We litigated that case for 5 years. It resulted in all of the injunctive relief that we had sought. It also resulted in a money settlement in the 9 figures, which I'm not at liberty to disclose the exact amount, but it resulted in that. And that led to many other representations in the telecommunications area. So, for example, when News Corporation and the Murdochs wanted to start what became, the Fox News Channel, Time Warner, which owned CNN because it had just merged with Turner Communications, said that they would not allow this new channel, the Fox News Channel, to operate in the areas where they were the cable monopolist, which included both New York and Los Angeles. You cannot start a national news channel if you are barred from the 2 most important media markets in the United States. So this was killing the nascent competitor, Fox News, in its crib. And we took on that case and we challenged what Time Warner was doing at the time. And we filed a Section 7 of the Clayton Act challenge to the merger between Time Warner and Turner Communications and saying that it was that merger which created the ability to block competition in those markets. And as a result of that, Fox News was able to be carried in all of the markets in the country. And the rest is history. For some people, the history is not so favorable. But this had nothing to do with the content on Fox News. At the time, nobody knew exactly what that content would be. But we do believe in competition. And that resulted in the kind of competition which now exists between CNN, MSNBC, and the Fox News channel. So that's another. And again, in all of these cases, we are this small firm going against the biggest firms in the country, and in some cases, the biggest firms in the world. And we've always thought that our size and our collegiality and our connection to each other it gives us an advantage in those cases. We have nothing to do but look to the left of us and the right of us to understand, why we are successful. So anyway, those are some additional cases.
And one other point, to quote Lloyd Constantine, which we all quote and know, is if you do everything, you will win. If you do everything, you will win. And that's what we try to do. So, did I misquote you, Lloyd? I hope not.
You quoted me. Of course, I stole that from Lyndon Baines Johnson. It was his motto. And what I always say is that we did everything that Johnson did, except we never cheated. Not to suggest that he did, but we did everything but cheat.
So not many firms can claim a track record that spans Fox News to the coalition of Immokalee workers. I have to express some deep pride in that. That was great. Let's talk about the present moment before we wrap up. Antitrust really matters right now. And of course, this discussion highlights it's always mattered, but now it's in the mainstream. Multiple bills floating around in Congress. New York is potentially passing a groundbreaking statute. And the private right of action is as important as ever. And our firm is still carrying out its mission. So I'd like you both to, speak and as holistically as you like, because you go back to the 80s when the debates started, because we're still having those debates. There are different versions. The economy has changed somewhat, if not significantly since then. Your views on where antitrust is going, where it should go, and what role the firm like Constantine Cannon can play in this really consequential moment in antitrust. So big topic. Let me start with the bidding with you, Lloyd. What do you think?
Yeah, well, Steve gets into this field before I do in the late 70s, which I think in many cases is probably the high watermark quantitatively of antitrust enforcement in the United States at all levels, certainly at the federal agency level, and I think private enforcement as well. And I would say that if you measured, antitrust at the time, the vigor of the enforcement, the amount of enforcement, et cetera, we've come to a point a couple of years ago where I would say antitrust was probably, somewhere between a third and a quarter of its former size. And I'll give you an example. When President Reagan took office in 1981, the Antitrust Division had 467 attorneys there. And when he left office, there were 209 attorneys there. Okay. There was a similar downsizing of the Federal Trade Commission during that period of time. Now, during that period of time, the economy grew and the number of mergers increased. There was a wave of mergers in the 1980s, and it continued in the 1990s and after the new millennium, et cetera. If you take a look at the level of concentration of American industry now as compared to then, most industries are much, much, much more highly concentrated than they were at the time. It used to be impossible to even conceive of a merger in an industry with, let's say, 5 or 6 companies to merge down from, let's say, 6 companies to 5 or from 5 companies to 4. Now, in many major markets, there are only 3 or 2 companies with the lion's share of the market. If you look at industries like defense, if you look at the banking industry, there's been massive concentration of those markets. And that is all due to the downsizing of antitrust enforcement over the last 40 or so years. And that is where we are now, or where we were a year or so ago. And you see now, as Jeff has said, much renewed interest in and devotion to antitrust, at least on a rhetorical level. You see it at the federal agencies, you see it in many of the state agencies, and you see it all around. There's, for example, in New York, a proposal to enact a new antitrust law for the state of New York, which in many ways will become the toughest, strongest antitrust law in the world. It's just one state, but remember that state of New York, which is also the home of New York City, has one of the largest economies in the world. If New York State were a country, it would be a top 20 country in the world in terms of its economy. So this is a period where antitrust not only, it continues to have the importance that it always had, but it has a lot of work to do. It's almost, and I don't like making sort of, odd analogies, but it's almost like the environmental issue. It's almost like climate change. We're dealing with a huge, huge problem and a huge deficit, which has built up due to inaction over the course of decades. And I think it's very much like that. The work that has to be done by the federal agencies, by the state agencies, and by the private bar is immense. It's not simply, current stuff. It has to do with this concentration of markets. It has to do with all of these problems which have occurred as a result of less enforcement, lax enforcement, and bad enforcement over the course of the last 4 decades. So, and one of the things that we try to do at our firm, at Constantine Cannon, is to think about antitrust, certainly, first and foremost, is what our clients want, what they come to us for. But when they come to us and they ask us, to represent them on the defense side or on the plaintiff side, we do that with the knowledge of the big picture of antitrust as well. And that knowledge that we have from our experience, I think, makes us better lawyers for them, and also makes us, I think, to some extent, better lawyers for, for the entire endeavor, which is for the marketplace. So that's the way I see it.
Steve?
Well, this probably is where Lloyd and I might diverge a bit, but he won't be shocked to hear that. But, in some sense, Jeff, antitrust has almost always been at a crossroads. And it's because of the nature of how it was created, and especially in the Sherman Act, especially Section 1 of the Sherman Act, which basically is a principle of law and how conduct should occur, as opposed to an entire list or group of rules of what you may and may not do. And so therefore, while certainly antitrust lawyers and the antitrust community can always coalesce on certain principles, i.e., the innate harmful effects of cartel activity. No one disagrees about that. And when you get beyond that, and that's what Lloyd points out so correctly about antitrust enforcement or activity like in the 70s, which was somewhat a high watermark. But that was where, in fact, one court observed at some point on a merger case that the only principle that I can glean from merger cases is that the government always wins. And that resonates with a lot of people on that. When I got to the Reagan, the Reagan administration, and before that, actually on the Senate Judiciary Committee staff as antitrust counsel, that was when the division led by Bill Baxter, who was a legend in the field, probably not known for his warm and fuzzy charm offensives, but Bill Baxter knew what he was talking about. He certainly had a confidence in that. That clashed with other people in the field who said, I'm just not sure that Bill Baxter is correct in terms of how you view the economic analysis of all of this. And that, of course, gets back to Judge Bork with the paradox. So I think that Lloyd started a little bit sooner than I did, but right when I was kind of coming into really being aware of all of this and how it all fit together, it was an incredible time in the debate and the analysis. And so while we have certainly, at least with the rhetoric that comes from different quarters today, you would say that we really are in a bit of a flux. It's one thing for people to talk about how the world should be and how the laws should operate, but it's another thing when you realize that in large part, these issues will get resolved by courts, not really by the Congress. I don't know. I don't follow it on a daily basis, but I think the odds of the Congress suddenly producing massive changes in the antitrust laws and some of the bills that are introduced now really go towards a more rules-based approach about what companies can and cannot do, then I don't know the likelihood of that. I will tell you this as kind of an interesting analogy here. Back in the early 80s, when I was on the committee staff, that was when the government's case against AT&T was really raging. And the government, as you know, was charging AT&T with a host of antitrust issues. At the very same time that case was being litigated, there was telecommunications reform legislation, as it was called, in Congress. And so in the early 80s, there was this race between the Justice Department's case against AT&T and what the Congress might do to restructure telecom. And that is when Bill Baxter, who was head of the division then, was told by the powers that be in the Reagan administration to go into Judge Green's court and to ask for a stay of about a year or so in the case to see if, in fact, the Congress would be able to resolve some of these issues that the department was focusing on. Judge Green basically replied, "What part of the word no don't you understand?" And so therefore, you had this force between the legislative branch and Judge Green in court trying to determine the future of telecom. And of course, the case was settled. And what I had always understood at the time was AT&T really decided they thought they might fare better dealing with one person, Judge Green, than 535 members of Congress on the House and the Senate side who didn't know a whole lot about communications, but were happy to do things anyway. And I have to say at one point, just to add, our colleague at the firm, Richard Levine, who is an invaluable member of our firm, Richard actually wrote the first draft of the modified final judgment, the consent decree that ended up breaking up AT&T. And having a conversation with Richard about what happened then is always a fascinating exercise.
So before we wrap, I want to ask one follow-up to both of you off of that. Lloyd mentioned New York and the supposed legislation in New York. And Steve, you talked about Washington, and we went, going back to the discussion of your histories. One of you came out of the States, and one of you was, a creature, if you will, of Washington. So let's just focus on that, this moment in time in antitrust And, starting with you, Lloyd, I want you to, if you could speak to the role the states can play, especially New York, in terms of, resurrecting antitrust in directions where antitrust will have a much bigger role to play in maintaining, a competitive economy that benefits consumers. Then Steve, come back and speak to what's going on in Washington,
Sure.
if you would. But first, let's start with Lloyd.
Yeah, well, the snapshot right now is as follows. Both at the Antitrust Division and at the FTC, new heads of those agencies and their top staff have been replaced. And those are people who want to be very, very active in enforcing the antitrust laws. And they also want changes to the antitrust laws to make them more powerful to deal with some of the problems that we've discussed up until now. That is impossible. That is impossible right now, given the current law, the current interpretation of the law, and the inability to significantly amend the antitrust laws. No amendment to the federal antitrust laws can occur right now. We're at a point in time where you cannot enact a Voting Rights Act. You cannot enact the Build Back Better law. Anything that the Biden administration wants to do in terms of major legislation and changing the antitrust law is very major legislation. It is impossible, as given the current Congress, how tight it is in the House of Representatives, 50-50 in the Senate, unless there's a change to the rules involving filibuster. So nothing can happen at the federal level. And the federal antitrust laws, given their current interpretation by the courts, are just not up to the task right now. I'll just give you an example. I talked about, mergers in an earlier period of 6-5 or 5-4, or certainly 4-3, to being impossible. Impossible. There was a trial last year in which the Sprint T-Mobile merger was approved. That was a merger, taking a market from 4-3. These were the two most competitive companies in the cell phone market, and that was allowed because of the current interpretation of the federal antitrust law. So right now, the federal agencies have to do the best that they can with what I've described as being a significantly weakened law. That creates the possibility and an opportunity at the state level. And I think New York is the most important state in that regard because, for two reasons. One, because it is New York. The two major states in this regard are New York and California, each which are world, class size economy. So New York and California are just different than any other states. And the second reason is that New York there is a bill which has already passed the New York State Senate. The New York government right now is pretty much a one-party government. The Senate is controlled by Democrats. The Assembly is controlled by Democrats. There's a Democratic governor. So it is not certain, but highly, highly likely that bill will be enacted. If it is enacted, as I've said, it will be very clearly the most powerful antitrust law in the world and the most powerful antitrust law that has ever existed in the world, since 1890. So if New York goes down that path, and this is not simply the New York Attorney General enforcing that law, it will create a private right of action in New York. And I see if that statute is passed, New York will become to some extent, the antitrust capital of the world. It will be a magnet for private actions as well. There will not be a significant antitrust case filed in the United States, which is either not filed under the New York antitrust law or at least filed under the federal statute with a pendant claim a pending state claim under the New York State antitrust statute. If that all happens, and I think there's a significant chance that that will happen in 2022, it will become a model for the other states. Now, something may happen in Congress. The filibuster rules may change. There may be an opportunity to do something with the federal statutes as well, along the lines that have been advocated by Senators Warren, Senator Klobuchar, and Representative Cicilline in the House. But until that happens, the most likely place for antitrust to get this huge jolt will be in the states, and the state where it's most likely to happen is the state of New York.
Steve, you diverged. I think the word you used was somewhat from Lloyd before. Do you want to diverge somewhat from Lloyd again?
Well,
on this point, or
sure.
It's
one of my favorite things to do, as you guys know. We always have spirited debates, but I don't disagree with Lloyd that significant changes in the law would be far more likely in somewhere like New York in the Congress, but not because of what you normally think of. Well, the Democrats think one way or support one bill and the Republicans are against it, or vice versa for that matter. As long as I've been involved in Washington in antitrust legislative matters, it's not really been a Democrat versus Republican divide. It has always been perhaps one industry as against another. One group of a group of companies beyond an industry versus another. And so what you see is, especially in antitrust legislative activity, as opposed to actually getting it done, is you'll see some what you might think of as pretty strange bedfellows on occasion politically. And so I just would caution that. And by the way, the filibuster rule comes into play because of that, because you still will have to have, critical mass in order to get something done. But when you watch this and you watch it closely, you just know that when I was on the Hill, actually, we got several antitrust bills done, like the National Cooperative Research Act, the Local Government Antitrust Act, and a couple of more. And those were actually Strom Thurmond, Howard Metzenbaum bills, which, ideologically they were viewed as being on the opposite side of the political spectrum. But we were able to come to some agreement and got it done. So telecom is exactly the same way, which was AT&T gets broken up in 82. The actual divestiture occurs in 84. And at that moment in time, everybody said, well, it's not healthy for one person, i.e. Judge Green, to be the telecommunications czar of the United States. So we're going to enact comprehensive telecommunications reform. Well, that was 1984. And the bill that actually got signed into law was signed into law in 1996. So it took 14 years that everybody could finally come to an agreement. And by then, as you know, the whole character and nature of the telecom industry had completely changed. So that's my point. And I think Lloyd's right about that. The New York statute or provision, if it actually were enacted, could have enormous consequences. And the fact is, because it is New York that has led the way over so many years. So,
okay, we could probably talk for hours more, but I think this conversation should wrap. We may have you guys back, as the pod evolves. There's no reason why you can't return. I would like to give you both, if you have any topic that we've talked about over the course of the last hour and 45 minutes, any parting thoughts. I'm going to give Lloyd the last word. So Steve, you can open up on this. If anything you want to say before we wrap, the floor is yours.
Well, as always, I'll give Lloyd my proxy for last words because he will take them anyway. It will. It makes no difference. But you know what? I don't. I've so enjoyed this conversation for a lot of reasons. Number one is it really gives me the opportunity personally to look back on what we've done. And I am an unabashed, absolutely non-objective fan and supporter and enthusiastic member of Constantine Cannon. It's just been really just kind of the honor in my life to do that and to watch it grow from about 7 or 8 when I first came into the orbit to now where we have offices, in New York and Washington and San Francisco and London. And we've expanded our practice to other areas, but it's just a pleasure to think back on it. And I have to say, I have always been and will always be a fan and have deep affection for my colleague, Mr. Constantine here. So, Lloyd, I hope I preempted a little bit of what you're going to say about me.
So what I'm going to say is one of the things that I did when I was a kid was I was a Boston Celtics fan, despite the fact that I was in New York. And I was a big fan of the Celtics and in particular Bill Russell. And I remember when he became, not just a player, but a player coach. And I watched him do that. And I sort of learned from him. And sort of over the course of the 27 years now, I've sort of fallen into that role. Right now, I'm playing a support role in a bunch of cases, sort of quasi coaching. And I'm just very proud of the firm. I'm proud of you, Jeff. I'm proud that you're the managing partner of the New York office. I'm proud of David and helping to support him on cases as well. And so the original idea has sort of worked out, not just the way that we wanted, but in many ways better than that we wanted. And it's been an awful lot of fun. It's been a lot of fun. I think we're very lucky to do something that is as much fun and as important as the things that we do. So that's all I'll say.
Well, this has been great. And I want to, on behalf of the pod, I want to thank you for this stroll down the history lane of this firm. Lloyd and Steve, I share your pride in what we've done, what you built, and what we're continuing to work on these days. And I think the firm has a key role, like it's always had in this moment. And antitrust matters. It really matters right now, and we're in the middle of it. And I'm proud of that. You guys will come back. We'll find ways to bring you back. But for now, thanks again for your time.
And let's get back to work, for heaven's sakes.
See you guys.
All right, guys. Thank you.
If you like the podcast, make sure to subscribe to Antitrust Matters and leave us comments on how we were doing or on the topics you would like us to cover going forward. You can also follow us on Twitter @CC Antitrust or follow the Constantine Cannon Antitrust team on LinkedIn. Until next time, be well and remember, antitrust matters.